this is the Business Guy, and I'm going to tell you 9 real reasons why some attorneys tell you not to protect your assets from lawsuits. Hey, don't expect an attorney who doesn't specialize in asset protection to jump up and down with excitement and tell you to set up an asset protection plan. Why? He'll be too worried about what the judge will think of him on the next 25 cases he brings before that judge. In addition to that, I'm going to give you 8 more reasons why many attorneys tell you not to protect your assets from lawsuits. So if you need to take action to protect yourself from a lawsuit, talk to somebody who specializes in asset protection from lawsuits. In over 3 decades that I've been in the asset protection field, I've trained our staff attorneys, and asset protection is not something they teach in law school. We're the largest asset protection company in the country with tremendously experienced attorneys and consultants on staff. After all, if you have a brain tumor, who are you going to see? You're going to see a brain surgeon, somebody who specializes in neurology. You're not going to want to go to see somebody who specializes in removing bunions from your feet. You want to talk to somebody who has experience taking the dang tumor out of your noggin. It's the same with attorneys. For asset protection, to protect your house, your cars, your bank account, your investments. I mean, this is your life savings we're talking about here. Consult someone who specializes in asset protection. By the way, if you appreciate this information, please click like below. My noggin would appreciate it. And if you haven't already, you can also click subscribe or follow so that when more videos come out like this, you'll be up to date right away. So here are the 9 reasons some attorneys give for not protecting your assets. Number 1, he doesn't understand asset protection. And that would be, from my experience, about 99.5% of attorneys. As we said, they don't teach asset protection in law school. In fact, every attorney, except for one who joined our staff, at first had little clue about how asset protection works and what to do. Instead, I had to share my 33 years of experience. What we do and how we do it works. And now we have some of the top asset protection attorneys in the world right here on our staff. So the attorney may not be knowledgeable enough about asset protection strategies, and rather than admitting their lack of expertise, they might discourage the client from seeking such protections. So asking an old attorney about asset protection is about as silly as asking your neighbor who just built a tree house how to build a mansion or a skyscraper. Hire a specialist. Number 2, he'll be worried about what that judge will think of him in the next 25 or so cases he brings before that judge. So that's not a concern about you. That's a concern about his own future career. After all, that attorney loses your case and you get a $5 million judgment. Your attorney is not going to whip out his checkbook and pay it for you. Hey, that's going to be on you. One attorney with our firm described it this way: the legal system feeds on taking money from the public and feeding the legal machine. So your money is what keeps the system going. So taking your money away from you and putting it into the hands of your opponent's attorney means that attorney keeps his job. There are more cases, demand for more judges, and job security for that judge, and the system remains a well-oiled machine with all the insiders within their little system getting paid. I know I'm getting philosophical here, but that really is what goes on behind the curtains. So that's why you need to get real and have one guy who specializes in fighting your case and another guy who specializes in protecting you in case the first guy loses. An asset protection specialist who doesn't have to worry about seeing that same judge another 25 times. You need an asset protection specialist. So both are needed. But one should not cross over and start telling you not to do the things that the specialist knows that you need to do. Just my opinion from what I've personally observed in my 33 years of experience. Number 3, that the judge will get mad and throw the book at you. Total nonsense in most cases. Why? Well, first of all, the fact that you have a trust at all usually comes out in asset discovery during a debtor's exam after the person has already won a judgment against you, not before. Even if it does perchance come out beforehand, it rarely has bearings on the merits of the case itself. It should not typically affect whether you win or lose the case. Plus, you are 10 times more likely to have your opponent drop the case altogether if they know they're not going to get anything. Which brings us to number 4. The attorney is worried that you won't need him or her anymore. If your assets are protected and your opponent drops the case, poof, there goes your attorney's paycheck. Income from you comes to a halt. Win or lose, your attorney only gets paid from you if the case keeps going. They say a good attorney can make a case drag on for a couple of years. A great attorney can make it last even longer. They have to put food on their table just like you and I do. Honestly, do you honestly think that doesn't happen for attorneys because it could lead to prolonged litigation, thus more billable hours so they can keep getting paid? I mean, honestly, are you kidding me? Of course they do. Number 5, they talk about fraudulent conveyance or fraudulent transfer. Same thing. A fraudulent transfer, fraudulent conveyance, now called a voidable transaction, is when somebody transfers or converts a non-exempt asset, such as cash, stock, or real estate, with the intent to delay or hinder collection by a creditor. I'm going to spend a bit more time on this because this is one of the most common misguided reasons. The important thing to know about a fraudulent conveyance is that it is generally a civil remedy only. It's by and large not a crime. And as the largest asset protection company in the nation, I have never heard of any of our clients going to jail for it, ever. So a client says, they might accuse me of fraudulent transfer. I say, okay, so? And I can almost see the wheels turning. I mean, fraudulent conveyance is like a barking dog in a cage. They wave their bony finger and say, fraudulent transfer. And then when your assets are properly protected, there's nothing they can do in most cases to back it up. The creditor's only remedy, and this has been established by many appellate decisions, is to undo or reverse the fraudulent transfer, which means that the debtor is back in the same position he was before he made the transfer, which is not reasonably possible if you have the right kind of asset protection trust. I've been in the asset protection business, as I've said, for over 33 years, and as of this video, I believe we have 102,000 clients and have done tens of thousands of corporate and trust filings. And whereas a handful of states have added this to their criminal code, it typically deals with a very specific intent. Because of fraudulent transfer laws, many domestic or U.S.-based asset protection trusts do not tend to work very well because a judge can easily undo the transfer. Whereas an offshore trust is outside of the local court's jurisdiction, and your local courts do not have the right to issue court orders to our foreign trustee company law firm. So the term fraudulent conveyance sounds scarier than it really is. It's simply a civil matter, not typically a criminal one, so in my experience, it's better to do it and then make them fight for it than it is to just roll over like a dead dog and leave your assets laying out there in the open. Put up a fight. Make them work harder to take your assets than you had to work to earn them in the first place. Now, fraudulent transfer laws are statutory, meaning they're written in the law books, and our local fraudulent transfer laws do not provide for criminal remedies, and they do not give the ability to assess additional damages or fees against the debtor. Now, there are certain drawbacks to attempting fraudulent conveyances that involve friends or family members. These people will often end up in a fraudulent transfer lawsuit. So what a misguided person often ends up doing is dragging the loved ones in on their problems. That is, people who tried to help you by receiving your assets get stuck with huge legal bills, and that won't be a happy conversation on Thanksgiving Day. So don't transfer assets to friends or loved ones. Don't transfer to a spouse. Dragging your wife into a lawsuit does not boost the romance. Instead, set up your own asset protection trust. Reason number 6, conflict of interest. The attorney might have a personal or professional connection to the opposing party or their lawyer. It's pretty common for opposing counsel to be good friends outside of the courtroom. This could drastically weaken your attorney's resolve and might advise the client against asset protection to consciously or unconsciously benefit the other side. Unfortunately, that happens. Number 7, misunderstanding of intent. The attorney may erroneously believe the setting of an asset protection plan is inherently unethical or illegal and thus advise their client against it to avoid what they incorrectly perceived as fraudulent actions. In fact, I've seen it over and over again where attorneys themselves misunderstand the term fraudulent transfer as merely a civil issue that has no teeth in most cases. And that's one reason why the term fraudulent transfer has been changed to voidable transaction. Nonetheless, 95% of attorneys still use the old term, even in modern law schools. Number 8, poor strategy. The attorney might think that appearing financially vulnerable could lead to a more sympathetic view from a judge or jury, or possibly encourage a more favorable settlement from that plaintiff. And that is a terrible strategy, because the opposing attorney has no more sympathy for you than a pack of lions has for a baby gazelle. You're just their next meal. Number 9, overconfidence in the outcome. The lawyer might be overly optimistic about winning the case and thus see no need for the client to protect his assets. However, I've seen literally hundreds of certain victories turn into huge losses that result in huge judgments against the defendant. One physician client of ours comes to mind. He was being sued by another physician over a business dispute. His attorney assured him that he would win. Fortunately, he did not share the overconfidence of his attorney. He lost big time, but he was able to keep all of his assets because he decided to have set up an asset protection plan. So those are the top 9 reasons why an attorney who does not specialize specifically in asset protection will tell you not to protect your assets from lawsuits. If you need help, please reach out to us at 1-954-400-1050 or fill out a free consultation form at assetprotectionplanners.com. Please like, subscribe, and share this video with others. Thanks for watching, and we'll see you next time. This is The Business Guy.